My name is Shama Elliott. I'm the Intellectual Property Manager of American International Group, also known as AIG. This is an educational video for trademark practitioners, and all of the opinions and thoughts expressed are with that in mind. Today I'll be speaking on the topic saying no to clients, choosing the right approach. As in house practitioners, while we're excited to learn about the new product developments and innovations in the company, we are often faced with the challenges of telling clients the mark is not available for use or registration. Over time, we have to develop a tactful yet artful way of saying no. So, how do we convey this in a way that one, steers them away from using marks that are not available, and two, encourage them to think more creatively? Today, we will discuss strategies and creative ways to say no to clients and choosing the right approach. In my practice, the insurance industry, we are the land of generic. I have developed a tactful way of saying we cannot protect descriptive terms. No third party has exclusive rights to said word, therefore, we cannot claim rights. This also means we cannot stop anyone else from using the name. There's often a misconception if we lock up a name, we have exclusive rights to that name. For example, there are many users of AIG, and in some cases, senior users of the acronym AIG. So we get several employees coming to us saying, how can they use our name? We have to explain there are different channels of trade, so in the eyes of trademark law, different trademark classifications allow us to coexist peacefully. However, this should be reviewed by IP counsel on a case-by-case basis as certain restrictions apply in foreign jurisdictions. This is sometimes less of an issue, but if there are any IP corporate guideline considerations, like at AIG, you may need to seek permission before using a company brand in front of a mark or descriptive term. Adding a stronger word to the name to create a more distinctive mark, or adding a house mark in front could be a good alternative. Encourage business groups to submit more than one name for clearance to increase the likelihood of a successful outcome. Most times, marketing is married to a name before they send the mark for clearance. Consider use with no registration for descriptive marks. Although this can be an option, it is highly recommended to search all terms prior to use. Utilize your corporate culture. Some companies, ownership of IP is a high priority. Others, if they can use the name without registration, they are comfortable with this strategy. Get to know your company's corporate culture and what often works best. Never forget, always enforce your corporate IP policy as necessary. Understand there is a risk, but in the end, it's a business decision. You should also consider if you are in the position to rebrand immediately if a conflict arises. Can you and the business assume this cost? And now we will hear from Chris Turk of VF Corporation, who will tell us his experiences with saying no to clients.
Thanks, Shama. Learning how and why to say no can be one of the most difficult things that we as trademark practitioners do, but it's also one of the most important. How often has a client come to you and said, we want to own this. We think we can own this particular field. I get it quite a bit. But when the marketing team or the product development team gives me a list of trademarks, they're barely suggestive, often just a combination of descriptive words. I think of walking into my local organic supermarket and seeing trademark by trademark, brand by brand, side by side, that have nature and path and organic and way. And they all have the same colors. They all look the same. Nothing pops. Nothing stands out. Saying no to my client when they come to me and say, we want to own this, but the only choices are descriptive mark, can be difficult. But it's the right thing to do. If you want to own something, it's incumbent upon us to help our clients come up with suggestive, strong trademarks that, quote-unquote, pop. I don't say no to be the department of no, but I do it to be a trusted partner to my clients.
Thank you, Chris. Also joining us is Sharon Sorkin of Wrigley Junior Company, who will share some of her experiences as well.
Thanks, Shama. Yeah, I agree. Saying no to clients is always difficult, and that's why I always follow a philosophy of a yes, but. and it works for building a relationship with the client. An example I can give from my own experience is a few years ago, our Orbit gum brand came to us and wanted to adopt the tagline, eat, drink, chew, globally, to encourage consumers to chew gum after eating and drinking. And of course, all of us might react similarly that a trademark like that, we would question the ability to own it because of its potential descriptive or non-distinct nature. But rather than saying no to going forward with the desired tagline, I worked with my team to offer up some possible options to make it more protectable. Those would be things like adding a distinct and unique, consistent visual element, adding sound or audio, ensuring that it's always marked with a trademark or circle R symbol as appropriate and listed in legal lines. Work with the business to avoid using it descriptively or in a sentence. Of course, register it everywhere that you can around the world and work hard not to disclaim any element of it. At the outset, collect evidence of exclusive and widespread use in order to have an acquired distinctiveness file ready to go, and manage the expectations of the business around what they can expect to own and what they can expect to tolerate in the marketplace, ultimately making a very collaborative relationship with the business and one that works for the future. So my philosophy of yes, but has always worked in this particular type of situation.
Thank you, Sharon. When you're faced with a situation when a client will not take no for an answer, I recommend considering the following tips. Clearly explain the risks of proceeding with names that have potential conflicts. Education sometimes softens the no. Provide alternatives and offer as many options before saying no. Lastly, can the company assume the risk if something goes wrong? How important is this mark to the company? Is it long-term use or will it be phased out in a few months? In closing, be sure to be firm and definitive, but avoid giving the impression they should not come to you for future matters. We want to welcome the company's ideas and at the same time enforce good IP practices. Overall, we want happy clients and peaceful IP practices. Hopefully, going through these tips and having a conversation with marketing, whether you're saying yes or no, will help mitigate the risks in choosing names that can be potentially problematic for you and your company.